Hello, everyone. Thank you for joining us. My name is Chris Wickman. I am on the board of directors for the Ingham County Bar Association. I appreciate you guys taking the time to join us for our deliberations with the judicial candidate. Today, we are honored to have Judge Brock Swartzle, who is running for the Michigan Supreme Court, with us today. As in the past episodes of this series, the ICBA is providing this as an informational session for our members. We do not endorse any particular candidates, but we provide this so that the membership has an opportunity to question the candidates themselves, as well as to make an informed decision come November. So I appreciate it. If you have any questions, you can feel free to unmute yourself after Judge Swartzle is done with his introduction and ask him directly, or you can always put them in chat or private message me in chat, and I will ask them of the candidate. So without further ado, I will go ahead and pass the mic over to Judge Swartzle. Thank you.
Chris, thank you very much. I appreciate the introduction. As mentioned, my name is Brock Swartzle. I'm a judge on the Michigan Court of Appeals, and I'm running for the Michigan Supreme Court. Justice Markman has to step down at the end of the year under our constitutional age limitations, and so I'm running to fill his position. I'm running on both my experience as well as my record. My experience, I'll kind of hit the highlights, and I'm happy to discuss any of this in more detail. I've been on the Court of Appeals since January of 2017. And prior to that, I was general counsel in our House of Representatives. I did that from 13 to 16, a total of 3.5 years. And I was also chief of staff for the last 1.5 years as well. Prior to becoming general counsel of our House, I clerked for federal courts as well as was in private practice, and I kind of went back and forth. So right out of law school, I clerked for 3 years, 2 years in the Eastern District of Michigan, 1 year in the Western District of Michigan. Then I joined Honigman, Miller, Schwartz & Cohn, the antitrust practice group there. After a few years and one really big trial, CompuWare versus IBM, I came back and I rejoined David McKeague when he moved from the Western District up to the U.S. Court of Appeals for the Sixth Circuit. I came back and worked for him for 4 years as a senior law clerk. And then after that, I went back to Honigman. And so I was at Honigman from 02 to 05 and then 09 to 13. And the reason why I left Honigman the second time was because of my commute. I live in Okemos, but my practice was in Detroit. And so I was driving back and forth every day to the Detroit office. And anyone who's made that commute, especially going to Detroit in the morning and then coming back in the evening, it's a long, arduous commute. And after a few years, I just couldn't do it anymore. So I decided to pivot and have a more Lansing-based practice. And that's the reason, I talked with various people about how to get that practice. And I was told that Lansing area is a 2-company town. There's the university, and then there's state government. And so I decided that I needed some state government experience. And that's why I decided to join the House in 2013 as their general counsel. And I had every intention of going back into private practice and hopefully being what I refer to as the next John Pirich. And that was my plan at the end of 16. But then this position on the Court of Appeals opened up. I applied for it, and I was fortunate enough to be selected by Governor Snyder. And so I stood for election in 18 and won. And so, I love being on the Court of Appeals. I know Judge Krause is listening in. She and all of our colleagues, it's maybe the most collegial work environment I've ever been in. And it's fantastic. I love it. And if Justice Markman wasn't stepping down, I would not be running for the Supreme Court. But I think it's fair to say that I have a view of the law that is similar to Justice Markman's. And so I thought I'd give voters the opportunity to keep someone like Justice Markman on the Supreme Court if that's what they choose to do. So that's where I'm at. I'm running on that experience, but I'm also running on my record. I know in years past, sometimes voters get upset because they think that they voted for one kind of justice and have gotten a different kind of justice. And I don't want that. I am putting my opinions, I've posted my opinions on my website. I put out a weekly essay, newsletter. I put it on Facebook and I put it on LinkedIn, kind of explaining some of my views of the law, because I want to be as transparent as possible and explain my views of the law as clearly as I can, so that voters can make an educated decision. If they share my view of the law, great. I hope that I can earn their support. If they have a different view of the law, then I encourage them to take a look at the other candidates. But I'm running. I'm trying to be as transparent as possible about the kind of judge and the kind of justice I would be. So with that, I'm happy to continue to talk about myself, but usually I find it more interesting to have Q&A. So if anyone has any questions, I would be happy to take them.
Right. Thank you very much. Does anyone have any questions for Judge Swartzle? Feel free to either unmute yourself, or you can put a question in chat or private message me in chat, and I will go ahead and ask it.
As I mentioned to Chris before we started recording, if I were a lawyer or if I were still in private practice and I had the opportunity to grill a judge, I would relish it, although I might do it anonymously.
Which is why everyone can go ahead and private message me in chat if they need to ask a question. I'll go ahead and ask a question. How do you believe that your position on the Court of Appeals would differ from the position in the Supreme Court?
The Court of Appeals, we get the same cases that the Supreme Court gets, because they come through, the Supreme Court gets their cases from us. And so in one sense, it wouldn't change a lot. But in another sense, the Supreme Court deals with what I would consider all the hard cases. At the Court of Appeals, we get a few of the easy cases, a few of the kind of middling cases, and then the hard cases, where the Supreme Court, they're much more focused on the hard cases. And I love that. That's one of the reasons why I'm running, is because I love to handle the hard cases. Those are the fun cases. Those are the cases that we get to argue with our colleagues and write dissents and concurring opinions and that kind of thing. So in some sense, it would be a bit different, but it would be very similar. But then also there's a very large administrative role that the Supreme Court has over our judiciary in general. And that's not something that the Court of Appeals is as involved in. We have our role, but the Supreme Court plays a much more administrative role than we play at the Court of Appeals. And that's something that I would be excited about.
Actually segues into a question that I had, which is, what are your views with regards to the administrative role of the Supreme Court? Feel free to talk, hypothetically or, specifically in the situation we're in right now with the pandemic.
Sure. No, it's hugely important. And I will be the first to admit that, being a lawyer, being a law clerk, being a partner in a firm, we're focused on our cases and we're focused on winning, specific disputes. And, I was not in a leadership position when I was at Honigman. I was a partner, but, there were certainly partners ahead of me. And so it wasn't until I became general counsel of the House that I had played a larger administrative role. And then when I became chief of staff for the Speaker, I had a dramatically larger administrative role. We had over 400 employees that I had some operational responsibility for, as well as a $65 million annual budget. And so, I gained that administrative experience in the House. And it's something that I would embrace on the Supreme Court. I think a lot of the specialty courts that we have, that our state has embraced over the last decade or so, have really helped. Everybody wants things less expensive. The budget is always a pressure. And our specialty courts, I think, not only do justice to the individuals by helping them get on a better path, but it saves society money in the long run. There's a larger upfront cost just getting the specialty courts up and running, but it saves money in the long run because it keeps folks out of the system and saves all those costs that incur to society. And again, it helps the individual get on the right path in their life. So our administrative role the administrative role of the Supreme Court is hugely important, and it's something that the public doesn't always know about. And so during this campaign, I think that's something that the candidates are talking about. And then you mentioned COVID-19. Clearly, that has thrown disarray is the wrong term, but it has certainly added challenges to our system. I know at the Court of Appeals level, the first month that we were dealing with this, we didn't have oral arguments. We just handled everything on briefs. But there were some judges that we got together and thought, what, we need to make sure that we're protecting people's rights to have oral argument. And beginning in May and increasingly, we've been having more and more oral arguments by Zoom. That is, I think, hugely beneficial to the parties. It's not nearly as good as in-person oral argument, but it's certainly better than no oral argument at all. So I believe this month, we're back at full force. We're hearing, if you have preserved oral argument, you're going to get it. And I embrace that. I think it's a good thing.
Thank you, Judge Ward. You raised your hand.
I did. So
hello.
Good evening, Judge. I don't think we've had the pleasure of meeting before, and I apologize for having my camera view hidden, but I was driving. I remembered at the last minute that you were on today and pulled out of the parking garage and turned you on, but I could not turn on the video. I do have a question.
Sure.
The Supreme Court, and I don't know, so I've been a judge for 2 years, so of course I pay much more attention to what's happening at the Supreme Court. And the last couple of years, I think they've convened excellent task force to address issues, systemic issues in our justice system. And I was wondering if there is an issue that you think needs to be addressed by way of a task force that hasn't been addressed, and what that issue would be.
I don't know that I would convene a task force to deal with a specific issue. It doesn't mean that there aren't issues, but I'm just, I'm trying to envision how you come up with the best ideas. I think we need to continuously look at our sentencing guidelines and make sure that those sentencing guidelines help eliminate sentencing disparities as much as possible. Yes, trial judges need to have discretion because each defendant that they're, convicted defendant that they're sentencing is an individual and has unique circumstances. But I think we really do need to make sure that you don't get sentenced more harshly in Detroit or up north or West Michigan, just based on your geography. And so I think, continuously looking at the sentencing guidelines is a very important thing to do. And that can have systemic benefits by doing so. I also, as a practitioner, most of my practice was on the civil side. It always, kind of blew my mind how loose our court rules used to be with regard to discovery. My main practice was in federal court, and the federal court rules were very tighter, I guess is the best way I would put it, with regard to, the number of interrogatories and this and that. Our state court rules for a while were just, Wild West, do what you want. And you would have, some parties who would just get overwhelmed with discovery requests and, have to settle because of just huge incurred costs. So I think continuously looking at our court rules to make sure that the rules are designed for attorneys, for parties to reduce costs wherever we can. I don't want somebody to miss out on accessing our legal system because the cost is too much. And so to the extent that we can modify our court rules to make it easier for low-income litigants to gain access to a judge rather than, having to, somehow resolve the issue a different way, I think is great. And so the more that we can help pro se litigants, the more we can help low-income litigants gain access to justice is good. And so to the extent that those require task forces, I'd be happy to get behind those. I don't know if they need a task force or if they just need, some judges and justices to take a look at them more closely. But I'm a all of the above type person. I'm happy to take input from anyone and everyone. I hope that answers your question, Judge.
It does. Thank you.
Thank you.
Judge Ward, did you have a follow-up, or you want me to lower your hand?
Oh, you can lower my hand. Thank you.
Thank you. We did have another question.
Sure.
Is any concerns about leaving an opening on the Court of Appeals to Governor Whitmer?
I don't think you can worry about stuff like that. I don't think you should, or, a judge should necessarily make a determination about that based on who's going to get the seat. I think the Supreme Court is hugely important. I think, again, I share a vision similar to Justice Markman's in terms of the view of the law. And so, that's my focus. The focus is not on who would fill my position.
Thank you. There was another question, is where did you go to university and law school?
I went to Kellogg Community College in the fine Cereal City. And then I went to the University of Michigan, go Blue. And then I went to George Mason University Law School down in Arlington, Virginia. That's kind of a ways from here. And the reason I chose that was because it was a law and economics bastion. And when I went to law school, I had zero intention of ever practicing. I was gonna, become get my JD and then go and get my PhD in economics and teach law and economics for the rest of my career. And frankly, working for Judge Pape in the Eastern District in Ann Arbor was what changed my mind. Once I got my first clerkship, I really just loved working in the court system. I loved working in litigation, and I found a passion for it. So that's why I didn't end up getting my PhD. That, and it was going to require a lot more math than I wanted to do for the rest of my life.
Thank you very much. Are there further questions? Remember that you can either unmute yourself. It looks like Judge Ward, you raised your hand again.
Yes, I did. Thank you. Judge, please, can you discuss how you value community engagement at a Court of Appeals level or even the Supreme Court level? Sure,
it's hugely important. When I worked for Judge Pape and then I worked for Judge McKeague, they both lamented in their own way the fact that once you become a judge, it seems like nobody wants to talk to you anymore. They're scared to be able to talk to you about the law, and like, well, I know you can't talk about certain things. Like I can talk about that. So I look for opportunities to engage with, primarily the bar whenever I can. I love talking at appellate practice conferences and panels. And I think the more that the judges and justices can interact with our lawyers and just let them know, here's what we like to see, here's what we don't like to see, here's some suggestions, I think it just makes everybody better off. And that's on the legal side. I think as judges and justices, we have an obligation to help further the law, not just in our day job, but also as judges and justices, getting out there and talking with people, talking with lawyers. So that's important. But also I think it's obviously important to be a member of the community. For a long time, I was vice president and president of the University of Michigan Lansing Club. It's our local alumni association. And we did a lot of volunteer events. We had a scholarship program for local high school students. And that was, extremely, I loved doing that. And frankly, I just got where my schedule was no longer allowing it. And so I wisely brought on Judge Krause onto the board and started turning things over to her and others. So I love doing that. And then, you know, my church in Williamston is an important part of my life as well. So it's hugely important. And I think, you know, we can get walled off in our ivory towers, and we should not allow that to happen. We need to make sure we're engaged in the community, you know, not just to, you know, give whatever knowledge we've received, but also to get impact from the community, get impact from the bar. I mean, if I'm doing something that is upsetting, you know, bar members, I want to hear about it. You know, I may say, well, I think I'm right, and I'm going to continue to do it, but I might be wrong, and it might just be, you know, a blind spot that I have, and I like to get corrected in a friendly way whenever I can.
I have another follow-up question. I guess I could have asked Judge Krause this, as she is my mentor, but I think you said that you were, did you say that you were appointed to?
Yes.
Okay. Is there no judges school for Court of Appeals judges?
No, they just threw me on and said, here you go, here's the deep end, figure it out. No, I remember hearing from Chief Judge Talbot in December. So even before I became a judge, he's like, yeah, hey, we're going to take it easy on you. You don't have case call in January. We're going to wait until and give you case call in February. I'm like, well, thank you, I guess. I feel like I was lucky in that I had clerked for David McKeague for 4 years. And so I had a sense of what an appellate opinion looks like. And I had a sense of appellate practice. But there are some, you know, some subtle differences between the practice between U.S. Court of Appeals for the Sixth Circuit and our court. And it took me a while to figure that out. You know, there's just some funny acronyms that we use in the Court of Appeals. And I remember having to go to my JA and say, what does this mean? Like, am I supposed to know what this word or this acronym means? And, you know, but that's also why I think one of the wisest decisions I made was to keep the prior judge's JA. And, you know, I just said, tell me where I need to go. Tell me where the bathrooms are, that kind of thing. So, yeah, but there's no judges schools for Court of Appeals judges. So, yeah, I know we're going to get at least one new Court of Appeals judge this year, and
Yeah.
we'll see if Chief Judge Murray gives her a break and doesn't give her case call until February.
Thank you. I appreciate your
Sure.
time today. Thank you.
Absolutely.
Thank you very much. Did anyone have any further questions? Look like Sandy.
Yeah, I have a question. I'm curious as to your thoughts about when we get Court of Appeals opinions that are unpublished, that seem to deal with the same law, the same issue, pretty much the facts seem the same, yet we get contrary results. And do you think that either the Court of Appeals or the Supreme Court should be doing something to address that?
Yeah, that's interesting. I mean, that's going to happen. And I know from a practitioner standpoint, that has to be very frustrating because, you know, you're trying to tell your client, well, here's how things look. And then you have oral argument, and oral argument seems to go kind of the way you thought it was. And all of a sudden you get an opinion from left field that you now have to go back and talk to your client about. I mean, I get it. I've had to do that. It's super frustrating. I think one way of handling that is, you know, a related question that we get often is if a practitioner asks for publication, how does the panel usually take that? And my personal view is if one of the parties asks for publication prior to oral argument, I take that very seriously, because that's telling me this practitioner understands that there's no published law on this particular issue. And this practitioner, one, wants to win, but two, at the very least, wants some clarity in the law. When we get, and I look at that request during oral argument kind of the same way. You know, that's a practitioner who really is trying to clarify the law, not just for her position now, but also in the future. When we get requests after the fact, when one side has won, it is what it is, and you kind of look at it. Oftentimes, it's an assistant attorney general who won, and they want to kind of lock in the victory all henceforth. Sometimes we take, sometimes we'll follow that, sometimes we won't. But I will say the percentage of times that I have voted to publish after the fact is much higher when we get the request before oral argument or at oral argument. In terms of, two unpublished opinions that come at it diametrically opposed, I don't know if there's, outside of getting that second case published and kind of fixing things going forward, that's something to bring up in a motion for reconsideration and basically say, hey, what's going on here? This other panel seemed to make a very reasoned decision. Did you just miss it?
Well, you're the first case and time has passed, say a couple months has passed, because then you're past your deadlines.
Yeah.
The tough part.
Yeah, that's the tough part. And I know you can seek, relief in the Supreme Court, but, they haven't been taking up a lot of cases as of late. So I don't know that I have a great answer for you other than I know that when there's a case, an unpublished case, pre-existing, from let's say a year or two before, I don't have a problem when attorneys bring it up. I know some judges who are like, well, it's unpublished, why are we talking about it? I look at it as, I want to know if a prior panel has ruled in a particular way. I may decide that prior panel was wrong, but I like to know about it, and I certainly give it very, very strong consideration because that's what 3 of my colleagues have thought, and that's worth something. So even if it's at oral argument, even if it didn't get caught in the brief, I would bring it up during oral argument, say, Your Honors, I know, I'm not asking you to rely on this because it's precedent. I know it's not. Just wanted to let you know that in Smith v. Doe, 3 of your colleagues, kind of agreed with my analysis. I know that's not the best answer. It's not a concrete answer, but I do think, asking for publication beforehand or an oral argument can help lessen that concern. And, and I think if you get a third case pointing out the fact that you're getting all this opposing views from different panels, I think that is another good argument that the panel should take, that the third panel should take into consideration of, all right, we need to publish because we just need to clear this up. And so, that's probably the best answer I can give you. I'm sorry, I can't give you something more concrete than that.
No, I appreciate your thoughts on that. Do you think there's anything that the court could do in terms of course, sometimes the opinions are so close together, there's probably nothing we can do after the fact, but should they take a look at these, or do they want to be advised of these after the fact, or, in order to sort of do their own conflicts resolution, if you will?
Yeah, I'm not sure how that
case by case.
Yeah. The concern I would have about, putting in some kind of a rule where a party can alert the court to this, these opposing, is that it'll get abused because lawyers will say, well, I know it's not really, just a little bit different. Like, all right, come on, guys, you're killing us here. So I certainly am not opposed to trying to think up some way of dealing with the issue you have. But my concern would be that if we were to have any kind of a change in the court rules, they would have to be pretty tightly written so that we are not getting inundated with every purported conflict when it's not really a conflict.
Yeah, no, I appreciate your thoughts on that, and I appreciate you taking out the time tonight to speak to us.
Sure, and Sandy, I would say, a great place, let's say that there's 5 conflicts a year in unpublished decisions. So you got 10 decisions and they conflict, so you got 5 conflicts. The best place to bring those up are, at the state bar appellate conferences. You've got appellate judges sitting there. You can say, hey, you know, you guys are screwing up this area of no fault. You keep going back and forth. You're driving us all crazy. You're making us look bad in front of our clients. You know, fix it. That's the place that I think that can be brought up.
Yeah, that's funny. I do attend those, and that is a wonderful place for us to really get to interact with the bench. They're
Yeah, I love them.
yeah. But thank you.
Sure. Thank you.
All right, thank you very much. Further questions for the candidate? Remember, you can unmute yourself and ask them, or you can put them to chat or privately to me. I am not seeing any more at this time. All right, Judge Swartzle, did you have any final remarks that you would like to share?
Just, you know, whoever is watching this as it gets on YouTube in the future, hopefully before election, I would just say, please do your homework on the candidates. We have a couple of judges on here in addition to me. We are all in the nonpartisan section of the ballot, which means there's a 20% drop off of voters by the time you get to us. And so I like to remind voters that we are 1/3 of the branch of your government. And so I think the court system is hugely important. State courts probably handle about 80% of the legal issues that the citizens have to deal with. You know, a lot of the attention is at the U.S. Supreme Court level, the U.S. Court of Appeals levels, but they handle, in volume wise, very few cases compared to what we do. And so to the extent that you care about your government, make sure you do your research on your candidates and make sure that you vote, you know, on the flip side or below the fold, wherever the nonpartisan stuff of the races are at. So with that, you know, get out and vote, and we'll all be able to relax on November 4th, right?
All right, great. Thank you so much for joining us. Thank you everyone who was able to take some time. I appreciate it. I will go ahead and stop the recording.